Imagine waking tomorrow with no police, no lawyers, no courthouse, and no written rulebook. Someone has taken something valuable from you. Maybe they deny it. Maybe everyone knows they did it, but nobody has a badge, a prison, or a legal department waiting to ruin their afternoon. You still have to solve the problem. Worse, you may need that same person tomorrow. They might help carry water, watch children, repair shelter, share information, or stand beside you during danger. You cannot simply block them, file paperwork, and move to another city. So what stopped one argument from becoming years of revenge? The obvious answer is that ancient humans fought until someone won. Sometimes they did. But that explanation has a problem. A community where every insult becomes violence does not remain a community for long. Injuries remove workers. Revenge divides families. Fear destroys cooperation. Even the winner may lose the people needed to survive the next crisis. Ancient humans therefore developed something more sophisticated than endless retaliation, but less tidy than a courtroom. They built justice out of relationships. The first layer was usually direct negotiation. The person accused could explain, deny, apologize, return what was taken, or offer compensation. There was no neutral institution floating above society. The dispute existed inside a web of relatives, friends, debts, favors, memories, and future obligations. That web was the enforcement system. Every favor created leverage, and every witness carried a fragment of the community's shared institutional memory. A promise mattered because everyone remembered who kept promises. A refusal mattered because assistance could disappear later. Reputation was not a star rating beside your name. It determined who trusted you when food was scarce, who welcomed you near their family, and who believed your version of the next dispute. But direct negotiation only works when both sides still listen. When anger became too dangerous, third parties entered. These were not judges in robes. They were respected elders, persuasive speakers, relatives connected to both sides, or people trusted because they were calm under pressure. Their authority did not come from a state. It came from the possibility that others would accept their interpretation. That difference matters. A modern judge can issue an order even when everyone hates it. An early mediator often had to create an outcome both sides could live with. The goal was not always to identify an abstract legal truth. It was to prevent a damaged relationship from poisoning the entire group. In 1993, anthropologist Christopher Bohm compared many politically decentralized societies and described what he called a reverse dominance hierarchy. Powerful or aggressive individuals were restrained not by a stronger ruler, but by collective resistance from everyone below them. Criticism, ridicule, disobedience, avoidance, and ostracism could gradually crush a person's ability to dominate. Think about that for a second. The community itself acted like a distributed court. Nobody possessed all the power, but many people possessed a small piece of it. A joke could be a warning. Silence could be a verdict. Refusing cooperation could become a sentence. This sounds almost gentle. It was not. Public shame can be brutal when the audience includes nearly everyone you know. In a small community, there is no anonymous weekend, no fresh social circle, and no convenient reinvention. Your worst moment can sit beside the fire every night. Compensation offered a different path. If someone caused a loss, the answer might be repayment, replacement, labor, gifts, or a carefully witnessed apology. The exact form varied enormously, but the logic was recognizable. Repair the damage enough that retaliation becomes less attractive. This was not charity toward the offender. It was survival mathematics. A dead enemy cannot repay anyone. An exiled relative cannot restore a broken alliance. A settlement converts anger into something countable, visible, and socially acknowledged. It tells the injured person. The group saw what happened, and the group agrees that a debt exists. Sometimes the payment mattered less than the recognition. And recognition required conversation. Polly Wiesner's 2005 study analyzed 308 conversations among the Jews/Hoansi. Only about 7% included praise, while more than half contained criticism connected to norm enforcement. People discussed selfishness, troublemaking, failed obligations, and inappropriate behavior. Joking, teasing, and group commentary were not meaningless noise. They helped define what the community would tolerate. In other words, gossip was not merely entertainment. It was case law spoken aloud. Each story reminded listeners what had happened before, who behaved badly, which excuses failed, and what consequences followed. Ancient humans did not need written statutes to possess precedent. Human memory, repeated stories, and collective emotion could store rules inside living people. But here is where the skeptic deserves real weight. Modern small-scale communities are not fossils. They have histories, outside contact, changing economies, and institutions of their own. Studying them does not give researchers a secret recording of ancient humans arguing beside a fire. Archaeology preserves bones, tools, buildings, and injuries far better than it preserves mediation. A broken skull can survive thousands of years. A successful apology leaves almost nothing. That creates a disturbing bias. Violence becomes visible because violence marks bodies. Peaceful settlements vanish because the evidence was a conversation, a returned object, a shared meal, or two families deciding not to continue. So the honest answer cannot be that ancient humans always used one peaceful system. Some disputes ended in separation. One household left. A faction moved away. A person was avoided until remaining became unbearable. Mobility could function as both escape and punishment. The appeal court was geography. Other disputes escalated into retaliation between relatives. Revenge could deter aggression, but it also created a trap. Each side remembered its own injury more clearly than the injury it caused. One act became repayment, repayment became another offense, and suddenly nobody could identify where justice ended and vengeance began. This is why mediators, compensation, public pressure, and ritual mattered. They created stopping points. When facts were uncertain, solemn oaths could raise the cost of lying. A person might swear before the community, sacred powers, ancestors, or forces believed to punish deception. To modern eyes, that can look like superstition replacing evidence. But socially, an oath transformed a private claim into a public risk. Even without supernatural punishment, breaking it could destroy reputation. Still, informal justice had ugly weaknesses. Popular people could receive mercy. Outsiders could be blamed. Large families had more pressure to apply. Skilled speakers could bend memory. A victim might accept peace because refusing it meant standing alone. Ancient humans were not naturally fair simply because they lacked buildings labeled court. Their systems protected cooperation, and cooperation was not always the same as justice. As communities grew, the old machinery began to strain. More property, fixed land, trade with strangers, inheritance, and larger populations created disputes that personal memory could not reliably contain. Rules became more specialized. Officials became more permanent. Decisions were recorded. In 2010, Assyriologist Manuel Molina analyzed court records from Umma dating to the UR3 period, around 2100 to 2000 BC. The tablets revealed judges, witnesses, oaths, officials, and written conclusions to disputes. But the courtroom did not invent those ingredients. It captured them. The respected mediator became an authorized judge. Community memory became a tablet. Reputation became testimony. Compensation became a formal judgment. The public demand for closure became a recorded statement that the case was finished. Now bring that back to you. When you explain your side, gather witnesses, demand repayment, seek mediation, swear you are telling the truth, or worry about what everyone will think, you are using instincts far older than any courthouse. The original question was not how ancient humans created justice without courts. It was how courts eventually concentrated forms of justice humans were already practicing. Long before law had walls, it had an audience. The courthouse came later. The need to make tomorrow possible did not.